This case concerned a butcher's shop adjoining the Metropolitan Hotel in Charters Towers in Queensland, which in the final years of the 19th century was hitting its peak as a thriving gold mining city. The parties entered into a contract for what was described simply as a butcher's shop adjoining the Metropolitan Hotel. The price was to be paid partly in cash and partly in goods. That sounds simple enough, right? Well, it turned out that the freehold title to the land was owned by a man named Erickson, who had leased out the parcel of land that the butchers stood on, and so the seller now held that lease. So there was a dispute between the parties as to exactly what was being sold. It couldn't be the freehold title to the land because that was owned by Erickson. Was it a sale of the rights under the lease? Or was it simply a sale of the actual shop itself, with no leasehold rights to the land beneath? Was it even possible to do this? Part of the problem with the whole contract was that there was nothing in the contract where the seller actually gave a warranty or a promise that they owned the land or the shop. And so the question became whether this should be implied into the contract. Chief Justice Griffith, who was then the Chief Justice of Queensland, but who was about to become the first Chief Justice of Australia, said the act of attempting to sell the shop, therefore, involved an assertion of his right to do so. It is a general rule applicable to every contract that each party agrees by implication to do all such things as are necessary on his part to enable the other party to have the benefit of the contract. In the case of a contract of sale, that rule is applied by implying a promise or warranty that the purchaser shall have a title to the property. The court found that the seller had tried to sell something he did not own. He could not sell the shop because the shop was a fixture on land owned by Erickson. As a result, the seller breached the implied term that he owned what he was trying to sell. The buyer, as a result, was awarded the grand sum of £30 damages for his trouble.